I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am
stop.
actually
Hold on. Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It does, it should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud. I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
That's not me.
No, I think
it's Judge Oakley. You'd have to ask Heather.
What happens when a defendant walks into court claiming he's not actually the person charged, that the court has no jurisdiction over him, and that criminal law is secretly commercial law? This isn't just another preliminary exam. This is a full-blown courtroom showdown between sovereign-style legal theories and straight Michigan criminal statutes. We're talking weapons charges, a prior felony conviction, a loaded pistol found at an airport terminal, and a judge who has clearly reached her limit. The real question is, can arguments about artificial persons and private capacity override hard criminal charges, or is this about a spiral into consequences the defendant never saw coming?
About that.
never seen a juvenile.
Good afternoon, sir. I was going to say good morning out of force of habit, but
Yes, it sometimes feels like a very long morning when we're still here. Good afternoon.
good afternoon. This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination in this matter. There is count one, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am, I'm actually here to get a better understanding of some things first.
What is it that you need to get a better understanding of, sir?
For one is the jurisdiction that the court is operating upon.
Judge, I'm gonna object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm gonna object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am, okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. And I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which
No,
suggests more than one thing.
Oh, yes, the jurisdiction of the court.
Okay.
You're going to,
Anything else?
yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
After it's pertaining to off your answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter. The court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
no. You still haven't stated the jurisdiction of the court for the record.
I have identified this court as the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee for the.
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the courts, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And while you're asking me, you also telling me that we about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you.
Okay,
But
so-
I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
Okay, I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your
Okay.
question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party and interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
this says that possession of a deadly weapon is a commercial crime. So we have to I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this civil or criminal? Because it doesn't make sense to me. So.
Mr. Michaud, you're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27 7211. All crimes are commercial. So I still I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress and coercion, I appoint Sullivan as my trustee for the record.
Mr. Sullivan, are you prepared to proceed this afternoon?
I am prepared to conduct a preliminary exam, yes.
Thank you. Your first witness, sir.
Judge, I do have a couple preliminary matters.
What are your preliminary matters, sir?
Pursuant to, well, first I'll start off and request a mutual order of sequestration.
Any objection?
No objection.
If there is anyone in this courtroom or anyone who is viewing these proceedings, as this court is live streaming as it does most of his exams, you should stop watching the live stream. If you're in this courtroom and intend to give testimony, not just today, but at any point in the future, you should exit yourself from this courtroom at this time. Is there anyone in this courtroom other than Mr. Michaud who is potentially a witness to this matter or will provide testimony in this matter? No response?
Judge, I believe that Crystal Watley was excused at the previous hearing by Judge Chief Oakley. And so we're requesting that she be excused.
Mr. Mohammed, I don't know. I know there are 4 people. One of them, I know who it is. The other 3, I don't know who they are. I have asked if there's anyone in this court's gallery or anyone who is viewing this court's YouTube live stream of this case. If you are giving testimony this afternoon or intend to give testimony at any point during the life of this case, that you stop viewing these proceedings or exit the courtroom. Maybe I wasn't clear when I asked them to absent themselves from the courtroom. Your next preliminary matter.
Judge, pursuant to 76611B, the people would like to introduce into evidence a certified record of conviction, which is this show that this individual was not allowed to be carrying a firearm on the day in question.
Mr. Sullivan.
Judge, I would object. I would note that this is a conviction from 2002. I don't believe that constitutes like a life ban on possession of weapons. This is over 20 years ago. So I would object on that basis.
Judge, my response is I will be citing People v. Perkins, which would indicate that the defense has the burden of producing evidence that the defendant's firearm rights have been restored, and I have printed out that case law for you to review if needed. However, that case law is People v. Perkins. May I approach with both the certified record of conviction and the case law?
You may approach. Any other preliminary matters, Mr. Mohammed?
Nothing from the people, Judge.
Any preliminary matters, Mr. Sullivan?
None at this time, Judge.
Thank you. Your first witness, sir.
And Judge, just briefly, in regards to our preliminary matter, mutual order sequestration, I'm also requesting an exception to the officer in charge, Detective Carmona, who's sitting to my left.
Any objection, Mr. Sullivan? Mr. Sullivan, I believe it's been the practice and procedure that the officers in charge are allowed to remain in the courtroom during the exam. So over your objection, the court will allow Detective Carmona to remain in the courtroom. Mr. Mohammed.
Thank you, Judge. The people call Officer Jonathan Steppen.
Sir, would you stop at this podium, state your first and last name, and then spell them both for the record?
Jonathan, Jonathan, Steppen, Stempin.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please come have a seat in this black chair that's closest to me. Mary Ann, my secretary, is recording your testimony. If she's unable to hear you, I'll ask you to either keep your voice up or move yourself closer to the microphone, okay? Thank you. Mr. Mohammed.
Good afternoon, officer. Can you please restate your name for the record?
Yep. Jonathan Steppen.
Officer Steppen, are you currently employed?
I am.
And who is your employer?
I am now with the city of Huntington Woods, but I was formerly at the Detroit Metro Airport Police Department.
Okay. And in what capacity are you employed as for the department?
Currently, I'm a public safety officer.
And previously at the other department?
Police officer.
And for how long at the previous department were you a police officer?
16 years.
Were you employed in this capacity as a police officer on February 23rd, 2021?
I was.
And did you work the state?
I did.
And did you work the state by yourself or with a partner?
By myself.
On this day, were you working in full uniform or modified uniform?
Full uniform.
And were you on foot patrol or in a scout vehicle?
Scout vehicle.
Was this scout vehicle marked?
It was.
Semi-marked or fully marked?
Fully marked.
And did your duties on the day of February 23rd, 2021 take you at or near the location of North Terminal, Upper Terminal Drive?
It did.
Is that located in the city of Romulus, County of Wayne?
It is.
Okay, what's at this location?
At that location is again, the North Terminal at Detroit Metro Airport.
And while at or near this location, did you observe something that drew your attention?
I did.
What did you observe?
I observed a unattended vehicle curbside in front of the terminal.
Okay, and when you made this observation, were you working in your capacity as a police officer?
I was.
For the airport?
Yes.
Okay, upon making this observation, what, if anything, did you do?
The vehicle was in a no parking zone. Exited my patrol vehicle, checked the interior of the vehicle from the exterior, with the aid of my flashlight to see if there's any occupants in the vehicle. There was not.
Okay. Upon making that observation that there was no occupants in this vehicle, what, if anything, did you do?
Due to it being in violation of the prohibited parking rule there, I requested a tow truck to impound the vehicle, and I returned to my patrol car to start writing the vehicle a prohibited parking citation.
Okay, now where exactly was this vehicle parked?
It was parked in front of the, at the time, it was called the North Terminal, now the Evans Terminal. It was parked directly in front of the terminal.
Okay, and it was left unattended.
It was left on.
And why did you call for a tow truck?
Again, because it was parked in a no parking zone.
And is that a ticketable offense?
It is.
Okay, now what occurred next, if anything?
Next, called for the tow truck, Martin's Towing, to be specific. Martin's Towing arrived and impounded the vehicle.
Okay. And did you observe that?
Yes, I observed the impound.
And can you describe what you mean by they impounded the vehicle?
So the tow truck basically hooks up to the tow or to the vehicle that's in violation, and depending on what stage it is, they'll sometimes just hook up to it. Sometimes they'll lift it. I can't recall if this particular case if he lifted it, but I can confirm that he did impound the vehicle.
Okay, and upon observing that impound, what, if anything, did you do?
So next, completed the citation. Checked if the vehicle was unlocked, which it was, and at that point, I conducted an inventory search of the vehicle.
Okay, and upon conducting an inventory search, did you discover anything?
Yes, I did.
What, if anything, did you discover?
In the interior of the vehicle, the center console to be exact, I located a Smith & Wesson M&P pistol.
Okay. And can you describe this weapon?
I don't recall what it looked like other than it was a pistol due to it being 3 years ago.
Okay. Now, upon making this observation, what, if anything, did you do?
Next, I secured the pistol.
Can you explain what you mean by secure?
So I removed the pistol from the vehicle and then locked it in my patrol car.
This right here is the turning point. The judge isn't debating philosophy anymore. She's enforcing courtroom authority. When a defendant refuses to answer a direct procedural question, yes or no, about whether he's proceeding with a preliminary exam, the court interprets that as obstruction, not intellectual debate. Contempt isn't about disagreeing with the judge. It's about disrupting the process. And 30 days in jail? That's not symbolic. That's real. Once jurisdiction has been established under Michigan criminal law, the court is not required to entertain repeated sovereignty arguments. So here's the question for you. Should a judge keep engaging with every theory presented, or does maintaining order in the courtroom come first?
Okay, was this pistol loaded?
Yes, it was.
Okay. Okay, now after securing it in your vehicle, what, if anything, did you do next?
Next, I checked the vehicle, or I'm sorry, I checked the pistol, its status to make sure it wasn't stolen. It was not stolen, and it came back registered to a Crystal lot.
Okay, and what, if anything, did you do next?
Next, I checked the license plate of the vehicle. The register owner was Frank Michaud Jr. After I checked him in lien, I checked
I
it.
object to hearsay. I don't know. Sounds as though the officers testifying to, I don't know what the basis of his testimony, knowing the owner of the vehicle.
I'm not really following the objection, Judge. I don't. What's the hearsay? He said he's objecting to hearsay. So what is the hearsay? There's no statement.
Right. So perhaps there could be some greater foundation as to how the officer knows who the owner of the vehicle is. Did he watch somebody purchase the vehicle? I presume no, but I presume the officer is relying on a record, and so I'm objecting to hearsay. That's a presumption, and if he's watched somebody purchase the vehicle, I will stand corrected. But he can only testify to personal knowledge.
And Judge, I believe he is testifying to personal knowledge. He conducted a lien search and it came back registered to the individual Frank Michaud.
I believe Mr. Sullivan's objection was requesting a more greater foundation before we get to that conclusion. Mr. Sullivan,
Yeah, he didn't testify that he did a lien search. He just testified as to who the owner of the vehicle is. So then my objection is to, if he did a lien search, my objection is to the vehicle.
Okay, I could lay a better foundation.
yes, sir.
Officer Steppen, after you conducted a lien search in regards to seeing who the registered owner is, what did you do next exactly?
I checked if the registered owner.
What did you check?
I checked if the registered owner had a concealed pistol license.
How did you do that?
Through lien.
Okay. And who was the registered owner of the vehicle after you conducted a lien search?
Frank Michaud Jr.
Again, I'm objecting to hearsay. It also seems there's some confusion about the officer. I think he's actually testifying about the owner of the weapon. He's testifying about the owner of the vehicle. I'm not sure exactly where all these things are coming from. They're all coming from lien, but I am objecting to hearsay.
As to the gun or as to the car, as to both?
As well.
Your objection is that he relied on lien as to the owner of the car?
Correct.
Okay.
And Judge, my response is this, it's not lien, or it's not hearsay. There's no out-of-court statement.
Lien is definitely an out-of-court statement that's being used for the truth of the matter asserted,
But
as to the
it's,
owner of the vehicle or the owner of the gun.
I'm sorry, Mr. Sullivan. I thought your objection started as to the ownership of the vehicle. I didn't hear you object when Officer Stimpin testified as to the ownership of the gun. So I'm with you on. Oh, no, I'm looking at you because you opened your mouth and I just didn't want to interrupt you.
I didn't want to interrupt.
No, no,
you, Judge. When the officer was asked the questions again, he backed up to the owner of the gun, and then the questions proceeded with, how did you know the owner? And so, you know, I suppose I'm objecting to both, but the first objection, you're correct, is as to the owner of the vehicle, and I think that that's where the lien search is coming in. I don't know how the officer is checking the ownership of the gun, so if I welcome further foundation, but if it is a lien search, then I am objecting. I think the lien search is an out-of-court statement, and it's certainly used for the truth of the matter asserted in the lien inquiry, the lien response.
Anything else, Mr. Mohammed?
I don't believe it is hearsay, and I don't think it's being offered for the truth of the matter asserted. It's just him performing an investigation, and he's testifying to his personal knowledge as to what he was doing. It's not being offered to show that this individual exactly did not have was not the registered owner, but it was just more into his investigation. And I don't believe lien is considered hearsay.
Anything else, Mr. Sullivan? Your objection is overruled. Officer Stimpin, you may answer the question if you recall the question.
Can you please repeat the question?
So after you conducted a search and you discovered that the weapon was not registered and the vehicle was not registered, or who the vehicle was registered to, what did you do next?
So after the vehicle was running lien and it returned to Mr. Michaud, I checked if he then had a concealed pistol license, which he did not.
And by he, you're referring to Frank Michaud?
Yes, the defendant.
Okay, now what occurred next, if anything?
After the pistol was secured in my patrol vehicle, I can't recall how exactly down to the minute when he came out, but the defendant eventually exited the terminal and then approached us as we were standing with the impounded vehicle.
Okay, and by that individual that approached you, do you see that individual in the courtroom today?
Yes, it's the defendant sitting at the defendant's table.
Can you please point to that individual and point out an article of clothing that individual is wearing?
He's wearing a white button-up shirt.
Your Honor, can you please let the record reflect that the witness has pointed to and identified the defendant?
Yes, sir.
Thank you. Now, what occurred next, if anything?
I asked Mr. Michaud if he drove the vehicle up to the airport that day.
And what was his response?
He stated he did.
Judge, may
What-
I place an objection on the record?
Hold on one second. Yes.
Just that Mr. Michaud, as he, at the onset of our hearing, Mr. Michaud introduced himself to Your Honor as the trustee of the Frank Michaud estate, beneficiary, excuse me, of the Frank Michaud estate. And so we just want that objection.
What's the objection? I'm sorry.
That I am not the Frank Anthony Michaud that he is referring to, which is a fictitious entity, a persons, which is a corporation, that I am the beneficiary of that corporation, that said estate, for the record, and I appointed you as trustee of that. I'm not a United States citizen. I am not the 14th Amendment citizen. The corporation, artificial person. I am a natural person, a flesh and blood living man on the land, for the record.
Mr. Sullivan, the court will note your objection for the record and will indicate that the way that this file was received by this court is State of Michigan versus Frank Anthony Michaud. The court has not received anything to change that caption. So if Officer Stempin refers to Mr. Michaud as Mr. Michaud, we will understand it to be as Mr. Michaud has identified himself at the beginning of these proceedings.
I understand, Judge, and I think identity is, something that Your Honor can make a ruling on. We're just noting an objection for the record.
Understood.
And
Thank you.
I have to object to that because I have sent in my authenticated birth certificate, which is authenticated, giving me full faith and credit from the United States of America, Secretary of State John F. Kerry, letting you know that I am the authorized representative of this state that you are administrating over, for the record. I also sent you a UCC lien. If you need to see my UCC lien, the Michigan that I have filed in Michigan means that I am the lien holder of this estate, as well as my commercial security agreement, as well as indemnity bonds or any other information you need. I have put it on the record, for the record.
And Mr. Michaud, the court has acknowledged Mr. Sullivan's objection. We will treat it as an ongoing objection, but has indicated that inasmuch as the complaint received in this case identifies you a specific way, the court will accept Officer Stempin and anyone else to proceed in that manner. So, Officer Stempin, your response to the question.
Officer Stempin, this individual that you pointed out here in the courtroom that approached you on that day, what was said to you by him?
Again, I asked him if he drove the vehicle up to the airport. He said yes. I then asked him if he drove it by himself or if he drove with someone else, and he said he drove the vehicle by himself.
Okay. Did this individual that you identified here in court ever produce to you a CPL license?
He did not.
Nothing further for this witness, Judge.
Thank you. Mr. Sullivan.
Thank you, Judge. Good afternoon, officer.
Good afternoon, sir.
It's your testimony that you conducted an inventory search in this case, correct?
Yes, sir.
And you performed the inventory search prior to the vehicle being towed, right?
That is incorrect.
Oh, it being impounded?
I conducted the inventory search once the vehicle was impounded.
Okay. So I'll rephrase. You conducted the inventory search pursuant to the car being impounded.
After the car was impounded, yes.
It's the department's policy that when a car is impounded, it needs to be inventoried.
Correct.
And so there are policies from the Detroit, what is it, the police, Detroit Metro Airport Police issue some policies regarding inventory searches.
Yes.
And those policies provide that when a car is being impounded, it needs to be inventoried.
Yes.
Okay. You said that you, well, I don't think you said, but you started the search at the passenger side of the vehicle, right?
I don't recall.
Objection, assuming facts not in evidence. That was never mentioned today.
I don't know.
Objections overruled. You may answer the question.
I don't recall.
Just a moment. Officer, your testimony earlier was that the car is impounded.
Yes.
And it was impounded, I think your testimony is that it was impounded when you conducted your search.
Yes.
And let's talk about the definition of impound. When we say impound, that could be as simple as lifted up onto the back of the tow truck.
I'm not sure what your definition is, but the departmental policy is as soon as the tow truck makes contact with the said vehicle, it is impounded.
Okay, thank you. That's my question is not as to my definition, but as yours. So in this case, the tow truck had made contact with the vehicle in question.
Correct.
And I believe that your testimony earlier was that you don't remember whether the car had been lifted up or not. Is that correct?
Correct.
But you just remember that there was enough contact.
I remember it was impounded.
Okay. And you don't remember the order of what you searched first?
No, sir.
Do you remember where you found the gun?
Yes.
You found it in the center console, correct?
Correct.
And that center console was closed when you found it in the center console?
I don't recall.
Okay. Do you recall whether you were entering the vehicle from the driver or passenger side?
Objection, relevance. I was, and knowing which side you entered the vehicle to conduct this inventory search relevant.
Judge, I think that the procedure that the officer is following when conducting inventory search is highly relevant. The officer testified that there is a policy, and so I'm just wanting to get a little bit more of a sense of how the inventory search is conducted and whether it's conducted according to policy.
Your objections overruled. You may answer the question if you recall the question.
I do not recall which side I started on.
Okay. During your search, you crossed paths with a pair of designer sunglasses.
Objection, relevance.
I don't believe that Mr. Sullivan was done with his question yet. Mr. Sullivan?
Thank you, Judge. My question is that at some point during your search, you came across a pair of designer sunglasses. Is that correct?
I don't recall.
Is there a list that you can refer to?
Not on me. I do not have one.
Did you generate a list in the process of conducting the search?
There was a tow tag generated.
So let me ask the question a different way. As you went through the vehicle, did you make a list of the things that you found in the vehicle?
I don't recall, but I should have, yes.
You are testifying that you should have made a list of the things that are in the vehicle.
I don't have the tow tag in front of me, so I can't testify to it.
Okay. You would agree with me that your policy is to complete a tow tag?
Correct.
And if a tow tag is not completed, that would be in a violation of your policy.
I can't speak to that.
Well, you just testified that it's policy to complete the tow tag.
Correct.
Okay. Would reviewing your report refresh your recollection as to whether you completed a tag?
I can take a look.
May I approach?
Yes, sir.
I'd like to see it.
First, you're opposing counsel for the record. May I approach?
Yes, sir.
Officer, I'm handing you a report. Tell me if you recognize it.
I do.
Is that your report?
It is.
Take a moment, review it. Let me know if it refreshes your recollection as to whether you completed a tow tag.
Okay. I don't believe it says on there.
I'm gonna direct your attention to the very last line here. This says the inventory search was documented on body worn camera.
Correct.
Does that mean that there is not a toe tag that's completed?
That is incorrect.
Okay, so your testimony is that it's inconclusive as to whether there's a toe tag completed?
Correct. Unless I can see it, I can't testify to it.
Okay, but you wrote in your report, the inventory search was documented on body worn.
Correct.
And it's fair to infer from that that it's not documented anywhere else.
I'm not going to agree with that.
Okay. But you, at this point, you can't testify to whether you completed a toe tag.
No.
He's answered, Judge, he's answered the question like multiple times. I don't know how many times.
I'm moving on. I'm sorry, Judge.
No, you're fine, Mr. Sullivan.
Do you recall coming across several pairs of shoes in the car?
I don't recall.
No list that you can refer to?
No, sir.
Do you recall coming across an umbrella?
I don't. I can't testify to that. I don't recall.
No list that you can refer to?
No.
You would agree that the purpose of an inventory search is to document the contents of the vehicle?
Correct.
So that when the vehicle is released to the owner, this prevents or protects the department from liability for stolen or missing property.
Yes.
And so the owner can see the list of things that's been inventoried at the time that the car was impounded. You would
Yes.
agree? And you can't tell me at this point whether that list was ever generated.
I can testify that it's per my report that it was documented on body worn camera.
But that's not, your testimony is that's not the police's policy, correct?
Objection, he's already mentioned, Judge, that he cannot testify to that.
That he can't testify to the policy?
No, not that he can't testify. He can't testify to everything that's in the policy. I mean, it could be hundreds of pages long. He can't testify to everything. He's testified to what he knows in his personal knowledge.
Hold on one second. Mr. Sullivan, your response to the objection?
Judge, I'm not asking about the entire contents of the policy, just sort of one provision of the policy, which I believe he's already testified to, and so I'm just looking for clarification. I believe his testimony was that policy dictates that he completes a tow card.
Your objection is overruled. You may respond to the question if you recall the question.
Can you repeat it, please?
Your testimony earlier is that the police policy is that you complete a tow card.
Correct.
The police policy is not that you document the contents of the vehicle via your body camera.
I can't speak to the specifics of the policy, whether it includes the body camera or not. Like the prosecutor states, the policy is quite extensive.
Are you aware of any instances when somebody goes to pick up their car from the impound lot, and upon picking up their car, they also receive a copy of your body worn camera? To your knowledge, has that ever happened?
Objection, relevance.
Judge, I'm again, my questions are about the purpose and the intent of an inventory. And if the officer doesn't quite remember whether or not the policy allows for the body worn camera to be substituted for a tow card, well, then maybe the officer will remember that sometimes people receive the body worn camera in lieu of a tow card
And
when they
I'm
go to pick up the car.
Respectfully, I'm also going to be objecting as to speculation.
I asked if he had, to his knowledge, I'm not asking him to speculate, I'm asking
As
to his
to-
knowledge. If he says he doesn't know, then I'll move on.
Your objection is overruled. The specific question is, are you aware of any instance where someone goes to retrieve their car, right?
That was my question.
A specific instance, not some random general question, correct?
I'm not asking him to speculate.
Right.
I'd prefer that he testify whether he's aware or not.
Do you recall the question, Officer Stimpen?
I'm not aware of that happening.
Officer, in your experience, when you complete a tow tag, you enter that tag into evidence, correct?
It's entered into the Columbus system.
Okay. It's turned over to the prosecutor.
I can't testify to that. I can just testify that once it's logged, it goes into the Columbus system.
What is the, I'm not.
The Columbus system is was the report writing system.
report writing system.
Correct.
So it's entered into the same file with all of the reports and other evidence which is generated in the case.
I'm not sure. Once I enter it, I'm not sure where it goes. I can tell you that it gets impounded or input into the police database.
And that's per your policy, is that it gets entered into the database.
Our policy is that it gets entered, yes.
Judge, may I approach
Approach whom?
the witness?
Thank you.
Sorry, I've previously shown to opposing counsel a video, which I'd like to approach the witness with.
You may approach.
Officer, I'm showing you a video.
Okay.
Do you recognize this?
Just for the record, I'll stipulate the introduction of any video. In relation to this case, in regards to his body worn camera, I'll just stipulate.
Stipulate to the court receiving the body worn camera video.
Correct.
Judge, I wasn't intending on admitting it into evidence. I was just going to ask the officer a few questions about the video. Are you able to identify this video?
Yes,
This is your body worn camera.
it appears so.
This is your conducting what you call an inventory search of the vehicle.
Yes,
Here we see you opening a shoebox.
okay.
Is that fair to say?
I'm not sure what that is. It's a box, I can tell you.
Okay. When you open that shoebox, that's a place where you're anticipating there might be things hidden.
I'm not sure hidden.
Okay. You want to make sure that there is no narcotics.
Now, this is where the legal confusion becomes obvious. The defendant cites federal regulations claiming all crimes are commercial, suggesting that because there's no injured private party, there's no real crime. But criminal law doesn't work that way. In state prosecutions, the injured party is the public, represented by the state of Michigan. And that's why the case is titled State of Michigan versus the defendant. Possession offenses, especially involving firearms and prior felonies, don't require a private victim standing in court. The legislature defines the conduct as criminal, and that's enough for prosecution. When the judge keeps narrowing it back to one question, are you prepared to proceed? She's not dodging. She's steering the case back to what legally matters. So let me ask you, should courts pause proceedings to dissect sovereign-style arguments, or move forward once probable cause is established?
In the car before you impound it?
No, that's not a point of an inventory search.
Okay. I'm going to continue playing the video. Okay. Okay, in the portion of the video that I just played, you open a toiletry bag, correct?
I'm not sure what that was.
It's a small compact bag in the back of the car.
Yes,
You unzip it, you shine a flashlight around inside, and you said brushes.
okay.
Is that correct?
I couldn't hear.
Okay. You didn't write down any of the things that you found in the bag,
Not at that moment, no.
and you didn't certainly didn't inventory the entire contents of the bag.
I can't testify to that.
You didn't remove anything from the bag.
I don't recall.
In that portion of the body worn camera, you're opening the compartment where the spare tire is kept, correct?
Correct.
You removed something from that compartment and you threw it into the truck.
It looked like something fell.
Okay. But do you know what that item was?
No,
You didn't document it in a list anywhere?
I can't tell you if I did or not.
And then in the video, we watch you close the trunk.
Correct.
Testified on direct that you ran a lien search to determine the owner of the weapon that you found,
Yes,
and the owner was a Crystal Watley,
yes,
and that's consistent with something that Mr. Michaud told you, correct? Mr. Michaud told you that that his girlfriend borrowed the car.
Objection, that was never raised at any point during any testimony, from my knowledge. He learned that from conducting a lien search, is what I recall, Judge. I believe that's a misrepresentation.
Judge, my understanding, and I've been practicing for a few years, is that I'm allowed to ask questions on cross-examination, which extend beyond the scope of the direct examination. Defense attorneys oftentimes do independent investigation, and this leads to questions that I sometimes like to ask on cross. And so please correct me if I have that wrong, but I don't think that I'm limited to the scope of the direct examination.
Judge, I'm just saying, I think he's misrepresenting his words. He said he learned that information based off of a lien search, is what I recall. It was never through the words of anybody else. That's what the testimony today has reflected, and that's, from what I recall, that's what he said. I'm incorrect, I withdraw, but pretty sure that's what he said, that it was, he learned that through a lien search.
Your objection's overruled. I believe the question was the lien search and through something Mr. Michaud said to you.
I'll back up and lay for the foundation, Judge. You had a conversation with Mr. Michaud, correct?
Yes,
You confronted him about the gun that you found.
I spoke to him, yes.
He told you that he believed it was his girlfriend's gun.
I don't recall. If I can take a look at again at my report, I might be able to tell you. Okay, I believe I'm ready. Can you repeat it just so I make sure I answer it correctly?
My question is, did Mr. Michaud tell you that he believed the gun belonged to his girlfriend?
Let's see here. Yes, he said that, yes, he stated that the gun may belong to his girlfriend,
Okay, I'll take it over.
Miss Wadley.
So that was consistent with what you learned in Lee.
I'm sorry?
That was consistent with what you learned in Lee.
Correct.
Your testimony earlier is that you don't recall whether the center console was open or closed when you conducted the search.
Correct.
Would an opportunity to review your body worn camera refresh your recollection as to whether you had to open the center console?
Yeah, let's take a look.
Does that refresh your recollection?
Yes, sir.
Do you recall whether you had to open the center console in order to locate the gun?
In that video, I had to open.
Okay, so the center console was closed when you began your search.
Yes, according to the video, yes.
No further questions, Judge.
Thank you, sir. Any redirect?
Very briefly. Officer Steppen, you mentioned that you had conducted an inventory search on this vehicle. Why did you conduct an inventory search?
Because the vehicle was in violation of the prohibited parking and was impounded.
I'm sorry, can you repeat that? I misunderstood the first.
Yes. So can you repeat your question? I just want to make sure I answer it correctly. or
Why did
understand
you conduct an inventory search on this vehicle?
Because the vehicle was impounded.
Okay, and why was it impounded?
Because the vehicle was in violation of the prohibited parking.
Okay, and is conducting an inventory search of a vehicle that's being impounded standard policy?
Yes.
Nothing further.
Thank you. Officer Stimpy, thank you for your testimony. You may step down.
Thank you.
Mr. Mohammed, your next witness.
No further witnesses, Judge.
Mr. Sullivan,
No witnesses, Judge.
argument.
Judge, the people moved to bind over on all counts. In regards to the CCW, Officer Steppen was performing his lawful duties as a police officer. He observed a vehicle that was just unoccupied and parked in a no parking zone. He then approached this vehicle and observed there was no occupants in the vehicle. Upon that observation, Officer Steppen then performed a search on the, well, prior to performing a search, he wrote up a citation for for parking in front of a terminal and it being unoccupied, and it being not occupied by any individuals. He then contacted the towing company who came and approached, and they took this vehicle that they may or may have not placed it onto their vehicle. He then conducted an inventory search pursuant to that, and he discovered a firearm. Shortly after, he testified here that he conducted a lien search and observed that this individual, Frank Michaud, the defendant, did not have a CPL license. He further testified that this is the individual who was the registered owner of the vehicle. Furthermore, he testified that at some point after, he was approached by the defendant, who he identified here in court, and that individual indicated to Officer Steffen that he was the only person who drove that vehicle there, and he was in possession of that vehicle. He's the one who brought that vehicle to that location. This vehicle was, a weapon was recovered from this vehicle, and the testimony reflects that the defendant in this case, who had an affirmative duty to produce a CPL license, failed to do so. Not only did he fail to produce a CPL license, he the lien search confirmed that he did not have one. Based on that, I believe the people have met their burden of probable cause and move for a bind over. In regards to the FIP charges, this individual has the burden to produce that he regained his firearm, his right to possessing a firearm. He failed to do so. People v. Perkins also reflects that he has failed to do so, and the burden is on the defendant to do that, not the people. So at this time, the people move for a bind over.
Mr. Sullivan.
Yes, Judge. Two arguments. One, I don't think the people have met their burden of probable cause as to Mr. Michaud being in knowing possession of this weapon. The testimony was that the weapon was discovered pursuant to an inventory search, and I'm going to get to that in a minute. I don't think this is an inventory search. But skipping that, the officer's testimony is that a gun is found in the vehicle, that it was not sort of readily apparent, it's not in plain view, but the officer had to open a center console in order to locate it, and that the gun is registered to an acquaintance of Mr. Michaud, and that was consistent with what Mr. Michaud told the officer. I don't think that establishes probable cause that Mr. Michaud was ever in knowing possession of the weapon, but that somebody else used the car, left something in the car. Mr. Michaud very well didn't know that had been left in the car. But I think that is a secondary issue. The primary issue here, Judge, is that the police are calling this an inventory search. And it's not controversial. We all know that a warrant is generally required in order to conduct a search. There are exceptions to the warrant requirement, but the government has the burden of proving the conditions of any exception are satisfied, and that's People versus Reed, 393 Michigan, Michigan Supreme Court opinion from 1975. The exception that I think the people are offering in this case is that for an inventory search, but the Michigan Supreme Court has been very clear in a case called People versus Toohey, that's spelled Toohey, a Michigan Supreme Court opinion from 1991, and I'll quote, "To be constitutional, an inventory search must be conducted in accordance with established departmental procedures, which all police officers are required to follow, and must not be used as a pretext for criminal investigation." Judge, I think that the search here is quite clearly a pretext for a criminal investigation. We've heard testimony that this officer is looking around in a bag, not making any notes as to what he's finding in the bag. He can't recall anything any particular things that he's found in the car. He's testified that he made no list of the things that he found in the car. He testified that the policy would require him to make a tow slip or generate a list of the things he's finding in the car. And so I don't think that the people have met their burden, certainly as to whether or not the officer is following established departmental procedures as required by People versus Toohey, but also the nature of this search, looking into a spare compartment where the tire is stored, looking into this bag, but not making any notes as to what they're finding. I think that it draws the reasonable inference that these officers are looking for narcotics or a gun. They're conducting a criminal investigation, and they're not conducting an inventory search pursuant to established departmental procedures. If there was a tow slip, the officer has testified that it would have been included in all of the reports. And if the tow slip exists, then I think we have a discovery violation, Judge, because it's never been turned over. The people don't have it. I don't have it. And so whether this becomes a discovery violation or a violation of People versus Tui, I think it's much clearer based on the officer's testimony that this is a violation of People versus Tui and that the officer did not complete the toe slip. The officer's testimony agreed with me that he wrote in his report that the body worn camera, quote, documented the inventory search, but that's not, but the officer also testified that that's inconsistent with the policy of producing a toe slip. And so, Judge, I think that this is an unconstitutional search, a search in violation of Mr. Michaud's rights. And so even the probable cause issue aside, the evidence of this gun should be suppressed. And then we definitely have no probable cause, Judge. The case should be dismissed. And I ask you to deny the prosecutor's motion for a bind over.
Judge, may I respond?
Yes, sir.
So Officer Stephan never mentioned that there wasn't a toe slip. He just said that he doesn't remember. And then in regards to, so what happened in this case, Judge, was that they observed a vehicle that was unoccupied. This is at an airport. There's nobody in the vehicle. They called for a tow truck company. The tow truck company came and they hooked it up. And then pursuant to standard policy of the police department, they performed an inventory search. There's nothing weird about it. It's standard between all police departments from my knowledge. Furthermore, this individual, the defendant, he exercised dominion and control of this vehicle, and this was displayed through the testimony of Officer Stephan. He said that the defendant told him that he drove the vehicle and he was the sole occupant. So this individual, the defendant, he exercised, at the very least, had constructive possession of the weapon. And so therefore, he had a duty on that day to produce a CPL license. He failed to do that. And the reason he failed to do that is because he doesn't have one. And that's what we're here for. The officer conducted a lien search. He confirmed this individual doesn't have a CPL license. So I believe at this time, Judge, the people have met their burden of probable cause, and we believe that at the very least, there is a question of fact for the trier of that. So I still move to bind over, Judge. Thank you for your time.
Thank you. This court was in receipt of a sealed copy of Mr. Michaud's record, and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stephan, and for purposes of this preliminary examination, will find that the people have met their burden and will bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue. Mr. Mohammed, is there anything else on behalf of the people?
Nothing on behalf of the people, Judge.
Mr. Sullivan, anything else on behalf of your client, sir?
Nothing else, Judge.
Thank you. That concludes this matter. That concludes this court's docket for the day. We stand adjourned.
At the end of the day, this case shifts from theory to evidence. The vehicle was parked illegally at Detroit Metro Airport. It was impounded, and during a documented inventory search, a loaded Smith & Wesson pistol was found inside a closed center console. The defendant admitted he drove the vehicle alone and did not have a concealed pistol license, and the prosecution presented evidence of a prior felony conviction. Those facts form the backbone of the bind-over request on felony firearm and felon in possession charges. Regardless of personal beliefs about jurisdiction or identity, criminal courts operate on statutory law, evidentiary standards, and procedure. Now I want to hear from you. Do you think the inventory search was properly handled, or did the defense raise valid concerns? If you found this breakdown insightful, hit that like button, drop your thoughts in the comments, share this video with someone who loves real courtroom drama, and don't forget to subscribe for more intense, no-nonsense legal analysis.